for a week.
I'm for the appellant.
Mr. A.R. Malhotra.
The matter is yet to be called up. Straight away, we're mentioning these on legs. We'll be having the motion matters, admission matters. It might take a while.
My lord, if it's possible, it may be adjourned for a week.
Say that. You say adjourn, we want adjournment. If you say on legs, then we'll wait for him. Mr. Fakuma, what do you say?
All right, my lord. But if possible, if you can have a fixed date, because this is a 2021 matter. So appeal.
We are ready to give you fixed dates, but this is what's happening. Ultimately, adjournments are being sought. That's why I had introduced these having of hearing matters in part 1 list.
If possible, Your Lordship, if we can take it up on the 28th of November, which is a Thursday, or 26th, which is a Tuesday.
Nismal Swami, you are there?
Yes, Your Lordship, I'm appearing for the state respondents.
We'll do one thing. We'll have it on 2nd of December.
Very well, my lord.
Please write down. Difficulty has been expressed on behalf of Mr. A.R. Malhotra, Learned Counsel, for the respondent numbers 1 and 2 to appear before the court today due to his engagement in other matters before a different court. Stop. On a mention made on his behalf and not objected to by the other side, let the matter be listed for hearing on 2nd December 2024. Or we can say like this, let it be listed for hearing in the weekly hearing list commencing from 2nd December 2024. Okay.
Oblige.
Lordship, I seek Lordship indulgence regarding this item number 5 of the hearing item. This we are planning to have a hearing on item number 7. So if this matter can be taken up some other day, item number 5, Lordship. Next week.
You are ready for item 7, Mr.
Yes,
Fakuma?
Lordship.
No, I'm asking Mr. Al Fakuma.
I'm ready for 7.
And have you spoken to Mr. Zoram Sana?
Yes, Lordship. I have already taken the consent of the other counsel.
Okay, as paid for by Ms. H. Lalmal Swami, Learned Government Advocate, appearing for the state respondents and not objected to by the other side. Matter stands adjourned for a week. Yes.
Give the apply.
For motion, item number 1.
May it please your lordship. My lord, this is a contempt petition that arises out of the judgment and order passed in WPC 194 of 2016. So, according to the judgment and order, the respondent number 5 and 6 were directed to deposit the entire amount awarded by the collector, along with the assessment made towards solatium and interest, also for the delayed payment before respondent number 2 within a period of 4 months from the date of receipt of certified true copy. And the respondent number 2, who is the DC Mohammed, has after calculation and making assessment and for the interest for delayed payments and so on, the respondent he submitted the detailed calculation to respondent number 5 and 6 for necessary action on 23rd 8 2023 in compliance with the judgment and order dated 21/7 of 2023. And so the petitioners waited for the respondent to deposit the entire amount, which is now 54 crores 97 lakhs 99,140 and 38 paise with interest and at per 9% per annum to registry till the stipulated period of 4 months, which had elapsed. And however, payment has not been made till date. So hence the instant contempt petition. So,
So DC was directed to make the assessment.
yes, my lord.
That has been done.
It has been done, and it was forwarded to respondent number 5 and 6.
Now, first thing, why was the matter adjourned on the last date?
Because, my lord, in the last court date, I was made to inquire about the respondent number 5, who's
Have
the
you done
joint
it?
secretary.
Have you made the inquiry?
Yes, my lord. I have inquired, and I was told that the additional secretary is he handles the matter. He handles the he's in charge of the joint secretary also, my lord. As
Who?
he's the respondent number 4 in the instant petition. As joint secretary is not appointed, and as in there's no incumbency at the moment.
There's nobody holding the post of joint secretary.
No, my lord. That is what I'm told.
Then the respondent number 4,
Respondent number 4 is the additional secretary. It seems he handles he's in charge of both additional secretary and joint secretary. He's both, he handles the matter, my lord.
so the judgment was passed on which date?
It was 21/7/2023.
So whether your petition is barred by limitation?
No, my lord, because the cause of action for filing the contempt petition has begun from 5/12/2023.
What is that date? What is the significance of that date? 5/12?
Because the respondent number 5 and 6 had received the copy of the letter dated 23/8/2023 on 5/9/2023, and the Honorable Court has granted 3 months from the date of receipt of the same to make payment.
From where do you get that date? 5?
It is found in page number 106, my lord. It is the copy of letter.
Okay.
The receipt. It is the receipt.
Postal tract consignment.
Yes, my lord. It was received, delivered on 5/9/2023, and as the Honorable Court has granted 3 months from the date of receipt of the same to make payment for the awarded amount, my lord. So the cause of action arises from 5/12/2023, my lord.
Who has received this on 5/9?
Respondent number 5 and 6.
5 and 6. But there's nobody holding the post of 5, isn't it?
Yes, my lord. However, the additional secretary is in charge. So, the additional secretary must have received the letter.
So we'll issue notice to 3, 4, and 6.
Yes, my lord.
Secretary Home Mizoram is not required. DC Mahmud is not required for now. They have made the assessment. Joint Secretary is not by name, so there's nobody holding the post according to you.
Yes, my lord.
Please write down. Heard Miss Ruth Lalrod-Ferry, Learned Counsel for the petitioners, who submits that the judgment and order dated 21/7/2023 passed by this court in WPC number
194 of 2016.
194 of 2016 has not been complied with by the respondents, more particularly respondent numbers 3, 4, 5 and 6. Stop. She submits that as directed by this court, the respondent number 2 had made the assessment for payment of compensation to the petitioners as directed by this court, and thereafter had forwarded the same to the respondent numbers 5 and 6 on 23/8/2023. The same was received by the addressees on 5/9/2023. Despite receipt of the assessment, the compensation amount has not been deposited within a period of 3 weeks, within 3 months, as stipulated by this court. Having no alternative, the petitioners have filed the instant contempt petition. The learned counsel also submits that upon making an inquiry, she has been informed that there is no incumbent holding the post of Joint Secretary to the Government of India, Ministry of Home Affairs, Department of Border Management Roman 3, New Delhi, respondent number 5, and that the work of the Joint Secretary is taken care of by the Additional Secretary of the same ministry. Respondent number 4. Next para. In view of above, issue notice to respondent numbers 3, 4, and 6 only at this stage, making it returnable by 4 weeks. Petitioners to take steps for service of notice to them by registered post with ADD within 3 days. This is the matter again after 4 weeks.
Obliged.
For admission, item number 2.
May it please your lordship. My lord, in this case, the issues involved are no longer res integra, inasmuch as in a similarly situated cases, this court has already passed several orders. It's regarding that availing that additional increment for staff nurses working at ZMC. I was appointed as a ward superintendent in the year 2019.
How many petitioner?
Only one, my lord.
Okay.
So,
Ward superintendent.
yes, my lord, at ZMC.
When?
15th of May 2018, page 29,
15th of May.
2018, through MPSC. And I am a holder of MSc degree in nursing. My certificate is at page 28.
28.
Page 28.
28.
Yes.
MSc in?
Nursing.
Okay. This qualification you had before your entry?
Before my entry.
Okay.
And office memorandum dated 23rd of March 1988, wherein it was allowed that as far as MSc nursing is concerned, two increments,
Page?
page 33 is the type copy.
33.
At the bottom, serial number 2. Two increments not absorbable will be granted to the nursing staff possessing the following qualification. Serial number 2. Postgraduate degree in nursing, that is master in nursing. And this OM was continued at page 35, annexure 6, was allowed to be continued via office memorandum dated 15/1/2010.
Yes.
So, and two judgments dated 21/9/2015 and one common judgment dated 31/10/2016, both of which can be found at page 47 and 64 respectively. Page 47. Now, in this case, Your Lordship, in this case, certain notification of the state government stating that those two OMs would not be applicable to Mizoram was challenged, and they were finally set aside.
Okay.
And the next judgment, which is at page 64, was basically another judgment which was passed on the strength of this, the previous one.
Let us see the previous one.
Yes, Your Lordship. Page 47, annexure 13.
$125. This also refers to WPC 125.
Yes. Page 58 is the relevant page at para 18. May I read, Your Lordship?
Yes.
This court had set aside the office memorandum dated 30/4/2004 via its judgment in order dated 29/9/2014, passed in WPC number 125 of 2013. However, this order dated 22/9/2014 does not change the subject matter of the case in view of the fact that the petitioner's case for grant of enhanced additional increment again accrued when the office memorandum dated 23/3/1988 was continued via office memorandum dated 15/1/2010. The continuation of the office memorandum dated 23/3/1988 via office memorandum dated 15/1/2010 also implies that the office memorandum dated 23/3/1988 was discontinued prior to 15/1/2010. Accordingly, I find that though the petitioner had lost the right for claiming additional increment prior to the office memorandum dated 15/1/2010 due to delay and laches, the petitioner's case for additional increment have to be considered with effect from the issuance of the office memorandum dated 15/1/2010. In view of the reasons stated above, I direct the state respondents to consider the case of the petitioner for grant of additional increment as they attain their qualification as per office memorandum dated 23/3/1988 and which was continued by office memorandum dated 15/1/2010. The additional increments, if any, shall be paid to the petitioner as per law within the period of 6 months from the date of receipt of a certified copy of this order. And so, Your Lordship, on the strength of the judgments, I have submitted one representation at page 71,
71.
annexure 19,
Yes.
to the directors at MC.
You were not the petitioner in those cases.
No, I was not the petitioner in those cases.
But since you are similarly situated,
Yes,
you
Your
gave
Lordship.
one representation.
So I highlighted those writ petitions, and with Your Lordship's permission, I would like to start from the second paragraph. In this connection, I would like to state that I was appointed staff nurse and joined at 2nd IR Battalion, Khozol on forenoon of 5/9/2008 after possessing higher qualification BSc Nursing possessed on 16/10/2006 and subsequently possessed MSc Nursing on 2/2/2012, attested Xerox copies of which are enclosed herewith for favor of so-and-so. I would therefore like to request you to kindly grant me 2 additional increments non-absorbable with effect from 15/1/2010 by taking as precedent of my counterparts 14 nursing staff who are granted 2 additional increments non-absorbable with effect from so-and-so under the Health and Family Welfare Department and for which act of so-and-so. So. And so. Now, in reply to this letter, I have submitted one representation at page 71,
71.
annexure 19, to the directors at MC.
Yes.
And so, Your Lordship, on the strength of the judgments, I had submitted one representation at page 71, annexure 19, to the directors at MC. I was issued a letter dated 72 by the Undersecretary.
Just a minute.
My lord.
Is this your representation?
This is my representative, Lal
Lal
Ramsang
Ramsang.
Chongtu. This is the petitioner.
Yes, the second paragraph which you just read, it says that you were only having BSc nursing initially.
Initially.
Then during the course of your employment, you got the MSc nursing.
But, Your Lordship, this initially I was appointed as a staff nurse in the IR battalion. But by way of direct recruitment, I subsequently joined as a ward superintendent in ZMC.
You're not claiming the benefit for the appointment in the IR battalion,
no.
only from ZMC.
Because as per my humble interpretation, the office memorandum relates to departments under the Health and Family Welfare Department.
Okay.
So in the next page, Your
So
Lordship,
what happened to your representation?
yes, the reply is there at page 72. May I read, Your Lordship?
Yes.
With reference to your letter number cited above, I am directed to inform you that regarding the applicability of the Honorable High Court's judgment and order dated so-and-so in WPC number 79 of 2016, Finance Department has made a clarification by their ID number so-and-so, which states that it shall be admissible only to the petitioners who had obtained higher qualification after induction into service. Due to the above, and since P so-and-so, Ward Superintendent, is not a petitioner in the above mentioned writ petitions, additional increment could not be granted.
What does it say? Only admissible only to the petitioners who had obtained high qualification after induction.
After induction.
Is
according
that
to
what
them.
has been prescribed in the OM?
No, my lord. It doesn't say anything like that. In fact, at page, I had sought for the clarification which they have mentioned here. This ID number so-and-so dated 5/7/2019 under RTI Act. And that can be found at page 74.
Yes.
May I read, Your Lordship? Clarification on so-and-so, WPC so-and-so. Under Secretary Health and Family Welfare Department is informed that additional increment is to be granted to those possessing diploma, post-basic, BSc, and MSc, and after their appointment as staff nurse based on the judgment and order passed in WPC number 79 of 2016. The said provisions are to be applied only to the petitioners who obtain higher qualification after induction into service. Additional increment cannot be granted on account of having higher qualification at an entry stage at initial appointment.
So is this the reference being made to your reply given to you?
Yes, my lord. That was a reference.
5/7/19.
Yes.
So what does the OM provide for? That
OM basically
after you
provides
get
that-
inducted, if
Yes.
you get higher qualification, you'll be given
It
increment.
doesn't say anything about after or before or after. In fact, Your Lordship, if I can take Your Lordship's attention to one order passed by Your Lordship as recent as 1st of November, WPC 109 of 2024. These are like identical, so to say, from para 2, if I may, Your Lordship. It is the case of the petitioners that they have been appointed as ward superintendent in the Zoram Medical College. As for the petitioner number 1, she was initially appointed as a staff nurse under the said college and later on appointed as ward superintendent. The details of the appointment and qualification of the petitioners, which is provided under para number 2 of the writ petition in the form of chart, may be abstracted herein under. I will skip that, Your Lordship. Para 3. The petitioners contend that the qualification required to become staff nurse is GNM and for ward superintendent, BSc nursing. Since they all possess the qualification of MSc nursing at the time of their initial recruitment to their respective posts, they are entitled to receive appropriate increment in terms of FR 2710 and OM dated 15/1/2010. According to the petitioners, similarly situated person had approached this court through the WPC number so-and-so, and this court by order dated so-and-so had disposed of the writ petition with a direction to the respondent authorities to examine and verify the claim of the petitioners therein and to grant them increment as entitled to them within a period of 3 months, so-and-so. So in this case also it was allowed. And in fact, Your Lordship, I have one office order dated 9th September of 2024. I apologize for the quality of the print, Your Lordship. I received it right before the court started, so I could not take the liberty of having it typed out.
Check the spelling.
In pursuance of the principal, I apologize. May I read, Your Lordship?
Read.
In pursuance of Principal Director, Health and Family Welfare Department number so-and-so, and Government of Mizoram instructions conveyed by number so-and-so and Finance Department ID number so-and-so, read with judgment and order passed by the Honorable Gauhati High Court in WPC 75 and 73 of the following nursing staffs are hereby granted additional increment non-absorbable due to achievement of extra qualification for the post with retrospective effect from 15/1/2010 or the date of their regular appointment, whichever is later, as shown in the enclosed annexures.
Where is this 75, 73? Have you enclosed the judgment somewhere here?
No, my lord, but I have a copy.
Let's see.
I would like to take your lordship's attention to paragraph 16 onwards. Lordship has para 16?
No, just a minute.
Yes.
So a distinction has been drawn regarding incentive and benefit of increment. And interpretation of FR 27 shows that increment has to be given to those who were already in service or who had acquired the qualification while in service or before their service.
Yes. I think paragraph 17 would summarize everything.
And this has been acted upon
Acted upon.
by this notification of his order. You were referring to that finance OM. Let us go to that. What is that date by which your application representation was rejected?
Yes. Page 74, Annexure 22. In fact, Your Lordship, I am challenging this particular clarification also in this case.
Your appointment is as ward superintendent, 15/5/2018
My
in
lord.
ZMC,
Yes.
and your appointment can subsist.
Subsist.
You have been regularized.
I have been regularized.
When was that?
I don't have that particular information with me, Your Lordship. I can provide it during the course of the day, Your Lordship. The date of regularization, but I am still working as on date.
The WPC 62, 79, 78. This was a case wherein leave was granted to get the extra qualifications, isn't it?
And,
Which is the case which is similar to yours?
uh,
75.
this is the one I've just provided, 109 of 2024, because they also relate to ward superintendent and they had already obtained that MSc nursing at the time of their appointment.
And 75.
And this 75, I have relied on 75 due to the fact that the clarification which they have, the clarification issued by the law department, they have relied on the states have relied on that statement as their defense in their affidavit.
should regulate the fan, put it in the very slow mode, and you reduce the temperature. It's getting quite warm.
And in 75, Your Lordship, this Honorable Court has clearly held that whether they obtained the additional qualification prior to or after their appointment is irrelevant. And this particular judgment.
Yes, what was the case in 75?
So basically, the case was that
They also had obtained
whether yes, they had also obtained prior to their appointment.
prior to the appointment.
So that's why that benefit should also be extended to them. But that clarification, as per the government stand, was that it only relates to those who obtain higher qualification after their appointment.
So it's a single writ petitioner,
My lord.
and you have challenged the rejection of your representation
And the clarification.
and the clarification. Letter 13, where's this? Okay, 13 September 19 and 5/7 19 clarification. Yes, Miss Lalman Louis.
Well, Your Lordship, at the onset, I would like to state that in the previous hearing, we were waiting for the petitioner to file the rejoinder. So I was not aware that it was going to be a full-on admission hearing at this stage. However, Your Lordship, I would like to make a few submissions which are already submitted in our affidavit in opposition. And so, Your Lordship, in our affidavit in opposition, page number.
You have filed affidavit in opposition?
Yes,
Okay.
Your Lordship.
Okay. Yes, page?
Page number 12, Your Lordship. Sorry, page number 7, Your Lordship, pen number 12. So, Your Lordship, in pen number 12, may I read, Your Lordship?
Yes.
That with regard to statements made in pen number 21 of the writ petition, I say that the government of Mizoram has already issued an order that grant of additional increment by staff nurse on acquiring higher fresh qualification in pursuance of Government of India Ministry of Health and Family Welfare Department of Health OM dated 23/03/1988, which was continued vide OM dated 15/1/2010 is not applicable to ward superintendent working under Zoram Medical College. The petitioner has no right to claim benefit which is meant only for staff nurse. The petitioner was never a staff nurse under ZMC. She was recruited as ward superintendent. And now, Your Lordship, pen number 13, Your Lordship, that with regard to statements made in pen number 22 of the petition, I say the clarification issued by the Finance Department vide so-and-so letter dated 5/7/2019 is based on judgment order passed in WPC number 79/2016 and should not be made automatically applicable to staff nurse under ZMC. Now, Your Lordship,
So how do you distinguish this ward superintendent and staff nurse? Is there any difference?
Your Lordship, also the ZMC is a society, so and the increment was given only to nurses. It was not applicable to superintendents. It was only available to staff nurse.
How do you say that? All this benefit flows from the two OMs, isn't it? 1988 and 2010.
Yes, Your Lordship, but then the word superintendent under ZMC since 2022 6 2018 is not eligible to the benefits given under the OM dated 2303/1988 and OM number dated 15/01/2010 issued by the minister. This is given in our affidavit in opposition on page number 11, pair number 18, Your Lordship.
But we already have passed an order on 1/11/24. You were there on that day. You remember?
Yes, Your Lordship.
This case, WPC 109. Court said that is a covered case, and although you sought for some time, we will dispose of the matter. And in that case also, the petitioners are working as ward superintendent in ZMC. Only difference is that petitioner was initially appointed as staff nurse, later on appointed as ward superintendent.
And in this, Your Lordship, she was actually appointed as a ward superintendent and not the other way around. So there might be a slight difference in the facts on how she was appointed.
Ward superintendent are basically nurse only. It's a higher responsibility to supervise the ward.
Yes, Your Lordship.
As for staff nurse, they're detailed in all the wards, different wards, and the wards are being manned by this ward superintendent, who are basically nurse only. Anybody has any difference of opinion on that? What they do? Staff nurse, board superintendent.
Should, in my humble opinion, it would be the same, it's just that they will have added responsibilities of administration. Apart from that, taking care of patients, I think that should be the same.
What happens to the pay scale, pay structure?
Pay
Is
scale
it different? Staff nurse have a different pay, ward superintendent has a different pay? Oh,
I believe so, Your Lordship. There's slight difference. In any event, Your Lordship, the petitioners in 109 of 2024, they were all appointed as ward superintendent directly. It's there in the chart. Only one particular petitioner was initially appointed as a staff nurse. In any event,
so you have read paragraph 12 and 13. Any other stand here?
Your Lordship, another stand would be in pair number 11, Your Lordship. Page number 5. May I read, Your Lordship?
Yes.
That with regard to statements made in pair number 20 of the petition, I say that as per Finance Department's clarification, the judgment passed by the Honorable High Court via judgment and order dated 31/10/2016 in WPC 79 of 2016, increments are to be given only to the petitioners of the said writ petition. Ladam Sangit Tongthu, Ward Superintendent, ZMC, was aware of the order issued by the Government of Mizoram Finance Department via so-and-so dated 17/3/2016. She submitted representation to the Director, Zoram Medical College on 14/8/2019, knowing that there was an order from the government that additional increment claimed by the petitioner on basis of Government of India, Ministry of Health and Family Welfare, Department of Health, OM, dated 23/03/1988, which was continued via OM dated 15/1/2010, is not applicable for ward superintendent. under ZMC. The government of Mizoram of Health and Family Welfare Department in its letter dated 13/9/2019 informed the director ZMC that Lalemsangi Tongkhu, ward superintendent, ZMC was not a petitioner in WPC 79 of 2016 and that additional increment could not be granted to her in pursuance of government order indicated above. It is the policy of ZMC, which is registered society under the Mizoram Society Registration Act 2005, not to adopt instructions issued by the Ministry of Health, Family Welfare, Nursing Section through the Office Memorandum dated 23/09/1988 and OM dated 15/01/2010 regarding revision of rate of qualification paid to the nursing staff.
Any case in which ZMC nurses have been given this increment, Mr. Fakuma?
I apologize, Your Lordship.
ZMC, they say that it's a society.
My lord, in that regard, I think my learned friend is having a misconception about my nature of my appointment. I was not appointed as a ward superintendent at ZMC. I was appointed as a ward superintendent under the Health and Family Welfare Department, which is evident from my appointment letter at page 29.
29.
Yes. It is the respondent number 3 who issued this appointment letter, not the ZMC. I am posted in ZMC. It is, my appointment is to the department. Respondent number 3, Your Lordship, the Principal Director, Health and Family Welfare Department, Mizoram, Mysore. So my appointment is to the government, not the ZMC. It's just that I am posted at ZMC.
Your Lordship, if I may add, in pad number 15 of our affidavit of position, page number 9, we state that the petitioner was recruited as staff nurse under Government of Mizoram Home Department in a scale of pay of 6,500, 200.
No, correct. That also he has admitted to that. Initially, he was with the IR, Indian Reserve Battalion. Thereafter, he was appointed by the health and he was posted at ZMC.
So, Your Lordship, the question of granting of additional increment pursuant of memorandum dated 23/03/1988 and OM 15/1/2016 does not arise
Why?
in the case of ZMC, which is registered society, Your Lordship. So, I mean, she's asking for this increment while she's already employed, stationed at ZMC. If she was still stationed at the Home Police Department, that might be a different circumstance.
Anything else?
No, Your Lordship, that is all, Your Lordship.
Okay, please write down. Heard Mr. Lal Fakoma, learned counsel for the petitioner, and Ms. Lalmun Louis, learned government advocate, for all the respondents. Stop having regard to the nature of a controversy projected by the petitioner. The writ petition is taken up for disposal at the admission stage. Next para. It is the case of the petitioner that she was initially appointed as a staff nurse in the police department on 28/8/2008. Stop. Subsequently, she was appointed as ward superintendent.
Page 29.
By the principal director Health and Family Welfare Department on 15/5/2018. Stop. On being appointed as such, she was posted at Zoram Medical College, bracket ZMC, as ward superintendent, where she continues with her service till date. Stop. It is the case of the petitioner that she is entitled to receive 2 increments for having possessed the qualification of MSc Nursing which is more than the qualification required in order to be appointed as a ward superintendent. Stop. The benefit of being given 2 increments has clearly been stipulated in the office memorandum dated 23/3/1988 and thereafter White Office memorandum dated 15/1/2010. Stop. Therefore, the petitioner, being squarely covered by the office memorandum, she should be given the increments entitled to her. As was done in the case of other similarly situated persons. Next para, Mr. Nal Fakuma, Learned Counsel, submits that the petitioner, before filing the instant writ petition, approached the respondent authority concerned for grant of two additional increments for having acquired higher qualification on 14/8/2019. However, the same was rejected by communication dated 13/9/2019. In terms of the clarification made by the Finance Department, bracket PRU, Government of Mizoram, with ID dated 5/7/2019. So the Learned Counsel submits that the clarification given by the Finance Department cannot be sustained in view of the fact that this court in WPC number 75 of 2020 and 73 of 2020, which were disposed of by a common judgment and order dated 6/11/2023, has held that there cannot be any distinction drawn regarding the acquisition of qualification, whether before entry into service or after entry into service. Stop. The said interpretation was made by this court in view of the prescription of FR 27 bracket 10 bracket 1 bracket small a bracket small b and FR 27 bracket 10 bracket 2 bracket small a bracket small b.
I don't mean to interrupt, Your Lordship. If I may make one small submission on this point. Regarding that clarification issued by the Finance Department, the state government in their affidavit at para 13 has stated that para 13
Yes.
has stated that that clarification was issued in line with the judgment and order passed in WPC 79 of 2016. Para 13. And if we turn to this WPC 75 of 2020, this particular writ petition was dismissed in a writ appeal. The state had filed an appeal against this 79 of 2016. In WPC, in this judgment and order dated 6/11,
Where do you get that?
yes, 6/11, this WPC 75 of 2020, para 11. '79 of 2016.
What did I say last? Okay. Stop further. Cancel further. The learned counsel further submits that in fact the clarification issued by the Finance Department dated 5/7/2019 is based on the judgment and order passed in WPC number 79 of 2016. But however, the judgment and order rendered in the said writ petition was put to challenge in writ appeal. number 25 of 2017 by the state. And the same was dismissed by common judgment in orders dated 19/2/2019. Stop. He therefore submits that there is no basis for rejecting the representation of the petitioner. And as such, the impugned communication dated 13/9/2019 and the clarification dated 5/7/2019 should be set aside, and the petitioner be granted the benefit of the increments as entitled to her in terms of the office memorandums referred to here and above. Next para, Ms. Lalnun Louis, learned government advocate, on the other hand, by referring to the affidavit in opposition filed by the state respondents on 23/7/2024, submits that the office memorandum dated 23/3/1988 and office memorandum dated 15/1/2010 is meant for staff nurse and therefore not applicable for ward superintendent working under ZMC. Stop. She submits that ZMC is registered as a society under the Mizoram Societies Registration Act 2005 and therefore does not adopt the instructions issued by the Ministry of Health and Family Welfare (nursing section). Stop. Therefore, as the petitioner is working under ZMC, he cannot have a claim for being granted the increments as per the two office memorandums. To stop, she further submits that the judgments relied upon by the petitioner are specifically meant for the petitioner concerned and cannot be used as and cannot be applied to the case of the petitioner. Stop. She thus submits that the writ petition has no merit and the same should be dismissed. Stop. I have heard the submissions made by the learned counsels for the rival parties and I have perused the materials available on record. Stop. There is no dispute to the fact that the petitioner was appointed to the post of ward superintendent by appointment letter dated 15/5/2018, issued by the Principal Director, Health and Family Welfare Department, Government of Mizoram. In pay band Roman 2 dash rupees 9,300 dash 34,800 plus 4,600 GP. You'll get this in page 29, just in case. Stop. It is the case of the petitioner that after being appointed as such, she has been posted in the ZMC and where she's working till date. Stop. Statements to this effect is been made in paragraph number 5 of the writ petition. The respondents have filed their counter affidavit, and against paragraph number 5, they have offered no comments. Stop. Therefore, it is clear that they have admitted to the fact that the petitioner has been appointed by the Health and Family Welfare Department, Government of Mizoram, and posted in ZMC. Stop. The applicability of grant of incentives, not incentives, increments, in terms of the office memorandum dated 23/3/1988, has been dealt with by this court in a number of cases. Stop. The benefit of the said office memorandum stood extended by the subsequent office memorandum dated 15/1/2010. Stop. For the purpose of the instant case, as to whether the petitioner, having acquired the qualification of MSc Nursing prior to her appointment as ward superintendent, can be easily clarified from the judgment order dated 6/11/2023, passed by a coordinate bench of this court. Before judgment, you write common judgment, okay? In WPC number 75 and 73 and 75 of 2020. Of the 3 petitioners in WPC number 75 of 2020 were having diploma certificates and claim to be covered by paragraph number 1 small bracket small a of the office memorandum dated 15/1/2010 at the time of their regular appointment. Stop. The sole writ petitioner in WPC number 73 of 2020 claimed the grant of 2 increments in view of her qualification. And in terms of paragraph 1 bracket small b of the office memorandum dated 15/1/2010 at the time of her regular appointment to the post. Stop. In passing the common judgment and order, this court had clarified that the increments being sought for cannot be understood as incentives. In view of FR 27 bracket 10. Stop. It was therefore held that the state respondents have made a wrong interplay with words while considering the grant of, within inverted comma, additional increments, close inverted comma, with the grant of, open inverted comma, incentive, close inverted comma, full stop. For the sake of clarity and for brevity, paragraph 17 of the said common judgment order may be abstracted here under paragraph 17. Okay, this should be a red flag. Next paragraph. No material has been brought to the notice of this court that the above cited common judgment in order has been interfered with by a larger forum, and such being the position, there can be no doubt to the fact that the case of the instant petitioner is also squarely covered. Stop. It may also be stated herein that recently this court, by order dated 1/11/2024, passed in WPC number 109 of 2024, had directed the respondent authorities to consider the case of the petitioners therein for grant of the increments entitled to them in terms of the two office memorandums. And all the petitioners accepting the petitioner number 1, who was initially appointed as a staff nurse, were all appointed and regularized as ward superintendent in ZMC. Stop. Next para. Thus, upon due consideration, this court finds that the petitioner has made out a case for grant of additional increments in terms of his memorandums, as already cited here and above. Stop. Accordingly, the respondents are directed to consider the grant of the incentives entitled the petitioner by following all the formalities that may be required within a period of how much time was granted in those cases?
3 months.
3 months from the date of receipt of the certified copy of this order. The petition accordingly stands disposed of as allowed.
Deeply obliged.
Much obliged, Your Lordship.
Item number 3.
Please, Your Lordship, will be filing the affidavit today.
You are for the
Respondents, all the respondents.
CADC.
Yes.
What is the case about?
They were removed from service without any show cause notice matter. From
Termination.
Borapansuri Primary Health Center.
Parties are represented by their respective counsels. Mr. Lalsan Liana Kyangte, learned counsel appearing for all the respondents, submits that he will be filing the counter affidavit of the respondents during the course of the day. Stop. In view of above, let the matter be listed again after a week.
Yes.
My Lord.
Deeply obliged.
Item number 4.
Your Lordship, I'm appearing on behalf of my senior, Mr. Sit Lan Thiang Thema. He's on legs in the division bench. My Lord, in this matter, we have received the affidavit, but we will not be filing a reply. So if this matter may be adjourned after 2 weeks.
You have filed your affidavit?
Lordship, I'm appearing on behalf of respondent number 4. We are performer respondent, so we're not going to file affidavit in the position.
You'll not be filing.
Your Lordship, the state has already filed the affidavit and position.
How many respondents are there in all? 4.
4. 4, Your Lordship.
1, 2, 3 has filed.
That's my Lord.
4 will not be filing. What is your stand in the affidavit, Mr. Nandvi?
Lordship, basically, we have already taken our action regarding the same. I mean, whatever they have claimed for, we have. It is already under process, and I believe it can be disposed. But like the learned petitioner has stated, if the matter can be adjourned.
No, what they're saying is that they want the implementation of this Consumer Protection Direct Selling Rules 2011.
Yes, Your Lordship.
What are you saying on that? Are you
Your Lordship,
implementing
pan
or you're not
number-
implementing?
In pan number 6 of page 3, Your Lordship. So we have stated that, may I read, Your Lordship? That with regard to statements made in pan number 18 of the petition, I say that as stated in the previous comments under pan number 3, finalized draft adapted by the state government will be notified as soon as possible. In this regard, responses to the representation submitted by the Indus Viva Health Science Private Limited are as follows. What is expected from a direct selling enterprise in terms of compliance to ensure that we are allowed to operate freely? The reply is, according to the draft rules, direct selling entities are expected to comply with the following to ensure that they can operate freely. 1. Bring any changes with respect to compliance with the Consumer Protection Direct Selling Rules 2021 or any other applicable rules, laws to the information of the monitoring authority within 30 days. 2. Ensure the terms of contract between the direct selling entity and the direct sellers as equitable for both parties and no one is unfairly benefited. 3. Not to change or sell the ownership of the position of the direct sellers in the compensation structure. 4. Not to generate or trade any type of virtual digital currency. 5. Not to allow direct sellers to have multiple registrations with the same direct selling entity. 6. Not to provide any commitment of returns on investment to participants in the form of interest, salary, loan, etc. And what are the regulatory checks that we must adhere to apart from and in addition to direct selling rules 2021? The reply is, apart from the Consumer Protection Direct Selling Rules 2021, direct selling entities selling in a particular state must also comply with the following additional requirements. That is, 1. Comply with provisions of Consumer Protection Act 2019, Legal Metrology Act 2009, and other rules framed by the central or the state government. 2. To adhere to additional compliances specified by the state government where the direct selling entity is operating. 3. These additional state level compliances include restrictions on changing, selling direct seller positions, generating, trading virtual currencies, allowing multiple registration, and providing commitment of returns on investments. That the statement, so that is all, Your Lordship. And Your Lordship, may I read pan number 4, page number 2. Okay, yes, Your Lordship.
So that is why in paragraph 4 is not complete. You need to get more instructions on this.
Yes, Your Lordship.
Because you say that Government of India has developed its own draft rules and which was finalized in July of last year. Government is thinking of implementing this, adapting this draft rules.
Yes, Your Lordship.
So since July, I mean, it's more than a year now.
Yes, Your Lordship.
So this is not the up-to-date thing. See,
Yes, Your Lordship.
please write down. Mr. Seetlan Thiangtima, Learned Counsel, for the petitioner is said to be on legs in a different court and therefore adjournment has been sought on his behalf. Stop. Miss Baby Laltin Zwali, Learned Counsel appearing for respondent number 4, submits that the respondent number 4 only being a pro forma respondent will therefore not be filing Any counter affidavit? Stop. Ms. Lal Nunlui, learned government advocate, appears for respondent numbers 1 to 3 and submits that the counter affidavit has been filed. Next para. Upon perusing the counter affidavit, it is seen that against the statements made by the petitioner in paragraph number 3 of the writ petition, the respondents have made the following statements. Please abstract paragraph 4, A to A, page 2 of the counter affidavit. It's a red flag. Next para. Having regard to the stand taken as abstracted above, it only appears that the same is not up to date. Stop as such. The learned government advocate shall obtain up-to-date instructions in the matter and file an additional affidavit. Please read the sentence from the above extract. In the matter, full stop. The rest you cut. Up to the instruction of the matter. The instructions should be filed in the form of an additional affidavit within a period of 2 weeks from today. This is the matter again after 2 weeks.
Obliged.
One hearing is left, isn't it? So we'll come back after 5 minutes, okay?
For hearing, item number 7.
May it please your lordship.
Yes.
My lord, the issue involved in this particular case is only one. I'll try to make it as short as possible. The present petitioner's lands were acquired under the Highways Act for upgradation of the national highway. Now, as per the Highways Act, calculation is to be done as per the 2013 Land Acquisition Act. I apologize. So, as per Schedule 1 of the Right to Fair Compensation and Transparency Act of 2013, and in the first schedule, your lordship,
Yes.
yes, apologize.
Schedule 1.
Schedule 1 of the Act.
Yes.
So Schedule 1 of the Act provides the different components which needs to be considered while fixing the rate of compensation. At serial number 2, factor by which the market value is to be multiplied in the case of rural areas, 1 to 2, on the distance of the project from urban area as may be notified by the appropriate government. So it says the factor should be fixed between 1 to 2. And if your lordship can kindly turn to serial number 6,
Yes.
final award in rural areas. Market value of land mentioned against serial number 1 multiplied by the factor specified against serial number 2. So in other words, whatever factor, multiplication factor that is fixed by the government will have to be multiplied with the market value. But as far as urban area is concerned, it is fixed at 1. So regarding this, pursuant to this first schedule, serial number 2, a notification was issued by the state government at page 51 of my writ petition. I'll just come to the last paragraph.
Yes.
This is notification dated 11th September 2019. Whatever the amount of compensation for land and the financial assistance for rehabilitation and resettlement of displaced families or persons are to be determined as per the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 within the state of Mizoram. The multiplication factor for value of land acquired for determination of compensation for land shall be 1 for urban as well as for rural areas. This is the notification which we are aggrieved with. In our humble opinion, going by this act, going by the first schedule, the multiplication factor has to be fixed between 1 and 2, and it cannot just be fixed as 1. It says 1 to 2 based on the distance of project from the urban area. So depending on the distance of the project in the rural area measured from the nearest urban area, that factor should be extended from 1, 1.2, 1.3 up to 2. In this respect, your lordship, rural areas. I am a resident of Tsingtsi, and in fact, your lordship, I have submitted one RTI application which can be found at page 85. Sorry, 84. My query before the UD and PA was to provide me with a list of notified urban area. The reply is at page 86 onwards, and the village of Tsingtsi is not one of the notified towns. So
Tsingtsi.
I belong to the I belong to Tsingtsi, and Tsingtsi, as per this notification, will have to be considered to be a rural area.
This is a list of urban areas.
Yes. So Tsingtsi is not included. So in this respect, your lordship, in fact, other states like Bihar and Jharkhand, they had also fixed a multiplication factor common for both urban and rural area. And pursuant to that, the Ministry of Road and Transport and Highways had issued a guidelines saying that, look, this is not in the spirit of the schedule of the 2013 Act. Please take corrective measures. This guideline can be found at page 53, Annexure 6. So this is a land acquisition guidelines for comprehensive guidelines. And as far as the guideline for fixing this multiplication factor is concerned, it can be found at page 59. Paragraph number 6, it says issue of the multiplication factor. With your Lordship's permission, I would like to take your Lordship's attention to page 61, para 6.7. I would like to read from para 6.7. A number of states like West Bengal, Rajasthan, Maharashtra and other states have already notified the graded scale of multiplication factor as applicable in their respective jurisdiction. The position in this behalf is available with MORTH on the date of issue of these guidelines is enclosed as Annexure 3. While the matter is being taken up with the DOLR again to revisit its notification of 9th February so-and-so with regards to a single multiplication factor of 2 for the rural areas qua the UTs, the concerned officers of MORTH, NHI, AI and NHIDCL are advised to take up the matter with the states where a uniform MF of 2 has been notified for rural areas without using a scale, graded MF linking the distance of the project area from the urban limits. The chief secretaries of the concerned states like Bihar, Chhattisgarh, Gujarat, Jharkhand, Uttarakhand and Uttar Pradesh are requested to take necessary corrective measures in this matter in order to ensure that the multiplication factor notified in their respective states is in conformity with the legal provisions in the first schedule of the 2013 Act, as also advised by the Attorney General of India. So based on this, I'll just continue with 6.9. Keeping the aforesaid in view, it is clarified as under. The multiplication factor by which the market value is to be multiplied in case of urban area shall be 1, as specified in first schedule. The urban area shall mean the area situated, I'll just skip your Lordship. Number 2 is the multiplication factor by which the market value is to be multiplied in case of rural areas from the end point of urban limit shall be the one as notified by the concerned state government, being the appropriate government for such state. It may be noted that the multiplication factor notified by the state shall remain the same for the state government and the central government project. There cannot be two different sets of multiplication factors in the same state as already clarified by the Department of Land Resources, so and so. As regard the multiplication factor in the case of rural areas in the Union Territories, the multiplication factor shall be 2. So basically, these are the guidelines. So just to give an example of how multiplication factors have been notified in other states, Your Lordship, I would like to take Your Lordship's attention to page 72. This is the Annexure 3 which was referred in this ensuing paragraph which I just read. Page 72. At the top right corner, Annexure 3 is written. So for example, Your Lordship, the clarification which the direction was sent to the chief secretaries of this Bihar and Jharkhand for having this common multiplication factor. But other states such as Kerala, it can be seen that multiplication factor, depending on the kilometer, it keeps changing. Even in the next page, I think reference can also be made to serial number 12, the state of Meghalaya. So if the distance in kilometer from urban area is less than 10 kilometers, multiplication factor should be 1. Above 1.1, 1.2, then it goes on. So in our humble opinion, Your Lordship, and this would be in the spirit and intention of the legislation. It could not have been a common factor of 1 for both rural and urban. In our humble opinion, that would be in violation of the intention of the legislation provided in the first schedule. That is the only limited point of controversy, Your Lordship.
Multiplicand factor. How is it put into?
Yes, as provided in this serial number 6 of the first schedule. the multiplication factor will be used to multiply the land value. It will be in addition to the market value. I can give an example of the compensation that was given to me. Your Lordship can kindly turn to page 49, annexure 4. This is a small chit, page 49, annexure 4. This is a small chit that was given to the petitioners, which is basically a breakup of the compensation amount given to them. So,
Yes.
as per the first schedule, different components are taken into factor, such as land value, column number 6, MF, this is the multiplication factor, which is taken as 1.
So land value multiplied by 1.
Yes,
Same thing.
exactly. So, as per the schedule, multiplication factor cannot be the same for rural and urban. For rural, the multiplication has to change and it should extend up to 2.
No, for urban it's 1.
Urban is 1, it's fixed at 1.
Why is that?
It's provided in the schedule itself.
Now, what is the basis of having a multiplicand if it's only by 1?
Exactly, but this is one of
1
those...
crore into 1 is what? 1.
1 crore. So anyways, I
Of course,
think...
it goes in decimals, point something, then of course it'll make some difference.
Right. But I believe that this particular component is for the benefit of the rural people.
So let us see the examples which you have just cited regarding Meghalaya, Kerala and all that.
Yes, Your Worship. Page 7.
Urban areas is 1. And what about the market value?
Market,
See, perhaps the market value in urban areas is already so high.
maybe that's right.
That is why multiplicand factor is hardly required.
Right,
They could have said that no multiplicand factor
right.
instead of saying 1. There's nothing. 1 means nothing. Now, in case of the rural areas, like you said, depending on the distance,
Right. The
Distance,
value will keep decreasing, Your Lordship. The further it is from an urban area, the land value would decrease. I think,
based on the distance of project from the urban area.
yes.
So, the further it is, the more.
The market value will be lesser.
Sorry, the lesser would be. It would be.
In order to safeguard those poor rural dwellers, I believe that was the intention of the legislation.
No, but it's the other way around. Distance from urban area
Right.
up to 10 kilometers from outer limit of urban area is 1.2. So from 10 to 20, it'll be 1.4. It increases.
Correct.
It's the other way
So,
around.
no, what I mean to say is that what would be lesser, what I mean to say is that the market value of the land itself will be lesser. That's why, in order to safeguard that,
In order to compensate on that.
yes. Because,
You have submitted a representation
representation that I
or
have
only
not,
RTI?
only RTI.
What do they say in their counter? They say one is good enough for both.
Yes.
Any reasoning?
Uh,
See, basically what you're trying to impress upon the court is that the 2013 Act provides for this multiplication as per the first schedule.
right.
So wherein for urban areas, it is fixed at 1. In case of rural area, it need not be fixed at 1. It can go
Up to 2.
up to 2, depending upon the distance from the place of the project
Right.
to the urban area.
That is
So
all.
that has been just made equivalent to the urban area, 1,
Right.
as per this impute notification.
Yes.
And there are certain guidelines issued by the
Highway, Ministry of Highways.
Ministry of Highways saying that, see, we follow what has been given by the schedule. Depending upon the distance, you must try to implement fixing different multiplicants for that.
Right. In fact, Your Lordship, at page 72, this is the same annexure. States like Bihar and Jharkhand, they have fixed the multiplication factor at 2. That is the highest factor that can be fixed without mentioning the distance from the urban area. In spite of this, the guideline says that please take corrective measures. It cannot be a uniform number. It has to be measured from the distance from the nearest urban area. The highest factor was fixed. In spite of this, they were issued direction to take corrective measures.
Subject to what Ms. Malsomi has to say, I think they have missed the bus, isn't it? Whether you fix two or whether you fix one thing. I mean, how can you have this common thing?
Yes, it cannot be.
Then you might as well erase urban and rural. You just say area.
Just say area.
Neither urban nor rural. Area. For any area, 2. Multiplication is 2. Matter ends there. But if you say one is urban, one is rural, you cannot have 2 each for that. Because there's a great difference
Right.
of land value.
We cannot equate Aizawl with land value in Singchip, Your Lordship. There will be vast differences. I think that was the intention of the legislation for having this multiplication factor a different rate for rural area versus urban.
Do you have any authority on this?
This is a relatively new subject, that's why I couldn't find.
That's your case.
That's
Let
all.
us hear the other side. Ms. Malswamy,
Yes, Your Lordship. Lordship, in this page number 72, which my learned friend has referred, I think even the state of Haryana and Himachal Pradesh, they have fixed the multiplication factor as 1.
so you have copied that.
No,
Copy paste.
Your Lordship. The intention is there in the notification itself. It cannot be compared with other states, Lordship. In the notification itself, it's clearly mentioned in para number 3.
Yes. Please read.
Now, therefore, having regards to the situation of the land holdings and their utilizations within the state of Mizoram, which are different in various aspects as compared to those in other Indian states, the Governor of Mizoram is pleased to hereby notify for general information and compliance and so, Lordship. It cannot be compared with other states, Lordship. It's clearly written there in the notification itself. And moreover, Lordship, in the Act of 2013, there is no stipulation that the rural and the urban rates should not be same. It merely stated that from 1 to 2. Rate should be from 1 to 2.
See, if you complete this sentence in this paragraph 3,
Yes.
there's a mention about
The appeal.
there's a mention about the applicability of the Mizoram 2016
Yes.
Act and the 2013 Act.
Yes.
Now, this controversy is put at rest now,
Yes.
unless, of course, you go before a higher forum. The other day, I think the division bench has disposed of the
Yes.
writ appeals.
Yes.
The judgment of the learned single judge has been upheld. So now you have to go by the 2013 Act.
Yes.
If you go to the schedule, it says that it provides for urban and rural. Now, as a resident of this state, you also know very well the value of land in and around Aizawl cannot be comparable to any land in some interior village. So, it's not reasonable at all. There's no logic behind.
And
You give the same
Lordship,
rate to the
as per-
person in some interior place and the same rate in Aizawl. How can that be?
And regarding Lordship, in the present case, the land is situated in the Singchip village. And I think it's appropriate rate since it is the distance is very near from Sirchip town area. And Sirchip is notified as an urban area as mentioned in the annexure, which my learned friend has already shown the list of urban areas. And it is very nearby from the Sirchip village. This Singchip village is very nearby from Sirchip town area.
No, you do the measurement yourself. How far it is, how near it is. We are only concerned behind the spirit behind this act.
Yes.
You are also trying to justify with your paragraph 3, But paragraph 3 now, as it is, the entire thing cannot stand. Now things are changed now. Now there is some surety now that 2013 Act has to be applied, unless it has been upset by a higher forum. As on today, 2013 Act will have to apply. If it applies, you go by the schedule, and what the schedule provides, you have to consider that. The schedule doesn't say that you must give this much, that much. It just says between 1 to 2. So within 1 to 2, you can always consider what to give, what not to give. That is within the domain of the state. Let us see your affidavit in opposition. What statements have been made?
Very short, Lordship.
What is the main, which is the main
Para
paragraph?
number, it's regarding the case only, Lordship, the one which I've already submitted, that
Okay.
regarding chief relations, chief district,
Okay.
and that the,
So on that note,
There is
we'll direct you to reconsider this.
yes.
We'll set aside the notification, you reconsider that, and within a time frame. Heard Mr. Lal Fakoma, learned counsel for the petitioners, and Ms. H. Lalmal Swami, learned government advocate for all the respondents. Stop. By filing this writ petition, the petitioners have prayed for setting aside the notification dated 11/9/2019, bracket annexure 5, by which the multiplication factor for value of land acquired for determining of compensation for land has been fixed as 1, figure 1, both for urban areas as well as for rural areas. In terms of the first schedule of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, open bracket, act of 2013, close bracket, full stop. Next para. Mr. Lal Fakoma, learned counsel for the petitioners, submits that as per the first schedule of the Act of 2013, more particularly at serial number 2, it has been provided that the factor by which the market value is to be multiplied in the case of rural areas would range from 1 to TO2, 2. 1 and 2 you put figure. And shall be based on the distance of project from urban area as may be notified by the appropriate government. Stop. He submits that the same goes to show that it can be any figure between 1 and 2, depending on the distance from the urban area to the project site. Stop. However, the respondents have made the multiplication factor to be 1, both for rural as well as for urban area. Full stop. The learned counsel submits that in response to the information sought by the petitioner through RTI. Asking for the notified urban areas, the petitioner has been provided with a list of notified urban areas in the state of Mizoram, which does not include. Is it a town, Chingchip?
Chingchip, since it's not urban area, my humble opinion would be a village.
It's a village.
Chingchip village. Stop. Therefore, the land of the petitioner being situated in Chingchip, and which is a village and undisputedly a rural area, the same cannot be equated with that of an urban area. Stop. By making the multiplication factor common for urban and rural area, the petitioner has only been deprived of reasonable and adequate compensation for acquisition of his land. Under what act?
Highways Act,
Under the National Highways Act,
1956.
1956, which relates to the application of the Act of 2013. Full stop. He therefore submits that. No, he therefore submits that. You cancel that. Not required. Next para. The Learned Counsel further submits that the Ministry of Road Transport and Highways, Government of India, has been issuing advisories from time to time, including the advisory dated
28 December 2017.
28/12/2017, advising the states concerned through their chief secretaries to consider fixation of the multiplication factor as per the first schedule of the Act of 2013. Since many states have also been maintaining similar, have notified a single multiplicand factor common for both urban and rural areas. Stop. Drawing the attention of this court to the multiplication factor notified by some of the states such as Kerala, Meghalaya, Odisha, Rajasthan, etc. The Learned Counsel submits that the multiplicand factor has been fixed in such a manner by the states concerned that it varies from 1 to 2 depending upon the distance of the project from the urban area, which is in accordance with the mandate of Schedule 1 to the Act of 2013. To stop. However, in case of the state of Mizoram, by issuing the impugn notification dated 11/9/2019, a common multiplication factor has been prescribed both for urban and rural areas. And having regard to the prescription of the provisions of the Act of 2013, the impugned notification cannot be sustained and the same should be set aside. Next para. Ms. H. Lalmal Swami, learned government advocate, on the other hand, by referring to the counter affidavit filed by the respondents on 28/1/2022, submits that in the notification dated 11/9/2019, it has clearly been indicated that the situation of land holdings and their utilization within the state of Mizoram is different from that of other states in the country. So, therefore, having regard to the peculiarities of the state of Mizoram, and importantly, having regard to the fact that the applicability of the Act of 2013 or the Mizoram open bracket land acquisition, rehabilitation and resettlement close bracket Act, 2016 having not been settled, the respondent authority respondent, you replace it by competent. The competent authority in the state government has fixed and notified the multiplication factor found to be appropriate. Therefore, the notification dated 11/9/2019 should not be interfered with. Next para, I have considered the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. There is no dispute to the fact that serial number 2 of the first schedule to the Act of 2013 provides for factor by which market value is to be multiplied in case of rural areas, which shall range from 1 to 2, depending upon the distance of the project from the urban area. Serial number 6 of the first schedule provides that the market value serial number 3, not 6. Serial number 3 of the first schedule provides that the factor by which the market value is to be multiplied in case of urban areas is 1. Stop. Although fixation of the multiplication factor can be 1 in respect of rural areas, but having regard to the prescription, comma, it may not be constant, but may range from 1 to 2, depending on the distance of the project from the urban area, as notified by the appropriate government. Stop. In the reply to the RTI query made by the petitioner, comma, as many as 23 towns have been notified to be urban areas within the state of Mizoram. Stop. However, the same does not include Chingchip village. Stop. Therefore, in the considered view of this code, if the multiplication factor is made to be one as a common figure for both urban and rural areas, comma, the intent and purport of the Act of 2013 comma, more particularly in the first schedule will only be ignored and thereby depriving adequate and appropriate compensation to those having their land in rural areas and being acquired for any reason. Stop. Further, paragraph number 3 of the impute notification dated 11/9/2019 no, paragraph 3, you put that, before 3 you write paragraph number 1 and 3. Paragraph number 1 and 3 of the impute notification dated so and so. No, you write like this. Further, from there you rewrite, okay? Please rewrite. Further, writ appeal 70 of 2018 mentioned in the impute notification dated 11/9/2019 has already been disposed of by a division bench of this court by its judgment and order dated
30/10/2024.
30/10/2024. By dismissing the writ appeal, stop. In other words, the judgment and order dated 15/11/2018 passed by the learned single judge, judgment, you just put common, okay? Common judgment and order. Common judgment dated so and so. Passed by the learned single judge in WPC numbers 20 and 30 of 2014 has been upheld by the appellate court. Full stop. Therefore, unless the appellate court's decision is interfered with by a higher forum, there will be no dispute regarding. There cannot be any dispute regarding the applicability of the Act of 2013. Next para. Upon due consideration and after hearing the parties, this court is of the considered view that the notification dated 11/9/2019 cannot be sustained, as the same is not in conformity with the prescription of the first schedule to the Act of 2013. Stop. Accordingly, the same is set aside. Stop. The respondents are hereby directed to consider fixing appropriate multiplication factor strictly in terms of first schedule of the Act of 2013. By providing appropriate multiplication factor in respect of rural areas as may be found to be just and expedient and appropriate. Such exercise should be initiated and completed within a period of 3 months from the date of receipt of a certified copy of this order. The petition stands disposed of.
Deeply obliged. Deeply obliged.
Is this the last matter today? Okay.